you.
Thanks very much, and appreciate the contribution of all the deputies and thank them for their contribution and for taking the time to carefully consider the motion to extend the ARP scheme. It would be remiss of me, however, if I didn't particularly mention former Minister Roderick O'Gorman and acknowledge his sterling work in relation to this area and indeed in terms of provision of care for Ukrainians, so I do want to say that on the record. As provided for under the Civil Law Miscellaneous Provisions Act 2022, the draft order laid out before both houses of the Oireachtas cannot be made law until a resolution approving the order has been passed by each house. Therefore, approval of the motion in Dáil Éireann today is essential to ensure that the scheme doesn't lapse and that it continues to a further year. That is the sole purpose for consideration today, to extend the scheme until 2026. And I want to advise deputies, if you're voting against the motion, you're voting against the opportunity to extend the scheme until March 2026. That's the sole provision that's in the motion today. I'm keenly aware from correspondence that I've received of the need for certainty for hosts and for beneficiaries who fear that they will face a cliff edge in terms of supports. The scheme's extension will give clarity and assurance to those involved. Deputies, I would also like to reiterate that failure to extend the scheme presents significant risks. Should the scheme fall, some 37,600 beneficiaries could potentially be displaced into an already pressurised rental market or face a return to state contracted accommodation. The latter would be a regressive step for families who are integrating in communities and being given a sense of agency. Moreover, it would represent significant cost to the state and have an adverse impact on the tourism sector. I acknowledge the concerns raised by deputies today, particularly in relation to the possible displacement effect that the scheme has on a private rental market. I note the proposed amendment by Deputy Carty to limit the extension of the scheme to beneficiaries of temporary protection covered by the scheme who satisfy a means test. It's also proposed to restrict the scheme to applicants intending to host beneficiaries in their own residence and who have not availed of the rent a room scheme in the previous 12 months, so as not to affect the private rental sector. Finally, to extend the scheme to applicants and not in receipt of any additional or top-up payments from a beneficiary, and I oppose that motion. Deputies, it would appear that the matters raised in these proposed amendments to the ARP scheme would require an amendment to the primary legislation that established the scheme, the Civil Law Miscellaneous Provisions Act 22. They are therefore not matters that have a bearing on the motion under discussion, which is simply, I reiterate, to extend the scheme, nothing more and nothing less. On the issue of means testing for beneficiaries, it is important to note that the ARP is a goodwill payment to recognise the valued contribution of those who have opened their homes to those fleeing the war in Ukraine. With regard to so-called top-ups, the ARP does not create any obligation for the beneficiaries in the accommodation, such as payment of rent or provision of services. However, a beneficiary may agree with the host to contribute towards certain household costs, such as utilities. Deputy Carty's amendment to limit the scheme to those hosting in their primary residence would result in reduced availability of accommodation for beneficiaries in need of shelter. It would preclude unoccupied homes offered through the Offer a Home, such as holiday homes, which have been a valuable source of accommodation. It is clear that the scheme has been responsible for introducing an accommodation stream that would not have been otherwise available and which has been a vital element to the state's response to the Ukraine crisis in providing shelter to families who have lost their homes. The accommodation recognition payment is acknowledged as an effective instrument of public policy that we cannot afford to lose at this point. It is in our collective interest to ensure that the scheme does not fail, and I hope that members will support the motion simply to extend the scheme. Should the scheme be extended, its operation will be subject of planning across the relevant departments, and as I've already said, the future of the scheme will need to be reflected in the wider context of considering what comes after the Temporary Protection Directive. Just on another note, just to say that the draft order on the reduced payment will shortly be brought before the Oireachtas by my colleague, the Minister for Justice, following the transfer of functions. So the issue of reduced payment and otherwise will be a matter for the Minister for Justice in due course. It is not on the agenda today, nor is it part of the motion, as the purpose today is simply to extend the scheme, no more, no less, and be advised of that as you consider voting. So I confirm that I am not in a position to accept the amendments to the motion proposed today. The draft order being considered cannot be made law until a resolution approving the order has been passed by each House. Therefore, deputies, approval of the motion by the Dáil today is essential to ensure the continuation of the scheme for a further year. No more, no less. The continuation of the scheme. If you agree in principle with the scheme being in place, you vote in favour of the motion. Thank
you, Minister. So that